Blended families. This is a topic as estate planning and probate attorneys that we consistently see causing tons of heartache and headache in the court system when proper planning isn't done ahead of time. The most common scenario is it's a second marriage or just not the first marriage, and the new spouses each have children of their own, and maybe a house was purchased by one spouse prior to the second marriage, and just that spouse's name is on title of the house. Inevitably, what happens is the spouse who owns the property, their name is on title, passes away, and there's no plan in place. Now, if you are the surviving spouse, you're kind of thrusted into a nightmare in the court system. And as probate attorneys, we deal with this all the time, unfortunately. Under California law, in that kind of scenario, even if you were married for 30 years, if the property was purchased prior to marriage, it's the separate property of that spouse. And if you were never added on title, or if there was never a plan put in place ahead of time, when that spouse dies, as the surviving spouse, you don't default own the property. It goes to probate court if there's no plan in place, and depending on the children dynamics, you may be left with as little as 1/3 of that property, with the deceased spouse children owning as much as 2/3 of the property. Now, of course, the step-parent relationship often is not the strongest, and when we insert the probate court process into that, a lot of times we end up with a lot of headbutting in court and maybe being forced to sell the property that we had planned to continue living in for the rest of our lives. Now, we deal with this in the court system all the time, and it is always a nightmare for the surviving spouse. So if you are in a blended family scenario, we have children from previous relationships, we're in a second marriage or more type relationship, and we don't have a comprehensive estate plan in place, this is emergency mode for you. You need to get a comprehensive estate plan in place, and it's not something that you want to start with in a cheaper software-based estate plan. We offer those. I get it. I get the appeal of a simple software-based estate plan. Our firm created our own options, so I understand the appeal. But if you are in a blended family scenario, your family dynamics are probably too complex to utilize a simple approach, at least without talking to an estate planning attorney first. What you really want to have is a conversation with a knowledgeable estate planning attorney to talk through what your goals are, what each spouse's goals are with their property, what we consider separate, what we consider community property, and what we want to have happen when each of us passes away. And based on those goals, an estate planning attorney is going to be able to guide you on what makes the most sense for you. If after that conversation, a simple version of an estate plan works, that's great. I can refer you to that at that time. But what we found with blended family scenarios, more often than not, our goals and our wishes are usually more conducive to a comprehensive kind of bespoke estate plan that's going to be drafted by an attorney to actually meet your goals. And that's usually above and beyond what a software-based approach can do for you. Now, if this scenario describes your situation, we have kids from previous relationships and we're married and I'm not on title of the house and oh shoot, what does that mean for me? Give us a call. If you're anywhere in California and soon to be Texas, we can help you right from the comfort of your home to talk through what your options are and talk about building out an estate plan that works best for your needs.